Good afternoon, everyone. See, we were going through the second module, and suddenly we have to switch on to online lectures because most of the students have gone for internship, and we don't have much time left when you return on July 15th. Because after that, I guess the semester might end within 1 month or a half. So that to be too limited. Time will be a big constraint for us to complete the module within that short period of time, which I have already discussed with all those who are present in the class. So I do seek your support in this case because see, unless you are going through these lectures, we won't be able to complete the classes in time. So I expect you to go through each and every lecture that follows starting today. And I don't know if every one of you have been in the revision process which we went through for the first module. We have completed the revision of the first module. We have started the second, and second module speaks about the classification of administrative functions. We have had 25 classes so far. I guess you are all aware that you all returned after April 15, April 5, April 5, and we were having around 12 classes then. Then after that, we had a couple of classes, but many of you have not joined in the class because of your internship issues. And now we have come to this position where we have absolutely no students in the class, maybe like 2 or 3 students in the class. So after July 15, I don't think that you have much time left to complete the portions effectively. So as of now, the first module is over, the second module has been started, and the second module speaks about the classification of administrative functions. See, I'll just go through a revision for the legislative functions. As you know, see, the legislative function happens to be in something that has been done generally, and for expected to, it is expected to be in operation for some period of the future. So this generality and also this prospectivity was considered to be the incidence of identifying an administrative action as a legislative function. But we can see that in certain cases, the court has accorded certain um, certain benefits which were primarily provided to quasi-judicial functions alone. For example, the right to have a hearing. So when you consider the weaker sections case was a case in which certain uh, places were identified as slums. So when you identify a particular area as slum, the residents of that slum will receive certain benefits from the government and international bodies as well for their overall development. So in a later stage, this slum was denotified. So whatever benefits they were about to receive for them to be notified as a slum will be lost to them now. So they were not accorded a hearing in that point of time. Now the court intervened into the matter, and the court said that considering the particular case, considering the facts of the case, considering the merits in the situation, the residents of that locality have to be accorded a hearing, an opportunity of hearing. So this was the reasoning that that the court came across in the weaker sections case. So we could find that it was quite impossible at certain stages that a watertight compartment kind of classification can be made about the administrative functions into quasi-judicial, legislative, or administrative. But still, this classification holds value and is necessary because when a litigation is being brought before the court, the first thing that the court might look into is to for example, whether to apply the principles of natural justice. Principles of natural justice applies when it is a quasi-judicial function. It does not apply in the case of legislative or administrative function. So, in order to check whether this relevant administrative action requires the application of statutory principles plus these natural justice principles, First, the court has to identify whether it is a quasi-judicial function. Okay. So, if it's not a quasi-judicial function, then it's a legislative administrative function. Then the administrative authority is only required to follow the statutory provisions or the rules with regard to the same, and no other implied procedures are required to be followed. So, this is the situation in which the courts are required to classify the same. But later in this weaker sessions case, we would come across the fact that the courts have gone to this broader view of analyzing each and every factor in the matter, each and every matter upon the facts of each matter, and in accordance with the situation and the merits, and upon merits, the court shall accord the relief. For example, in the weaker sessions case, the court has accorded the relief of a hearing. So this is with regard to the legislative functions, and the legislative functions we have gone through an entire class in the, and we have provided notes also. So those who have not been in the class, please collect the notes and please go through the topic once again. You have any doubt, you are free to approach me. Okay, now we will go to the next classification. So this is called the quasi-judicial function. See, quasi-judicial is the name given when an administrative authority performs adjudicatory functions. See, quasi means not exact. When you say that an authority is performing quasi-judicial function, this particular function is by nature not exactly judicial, but not exactly administrative. It's right where somewhere in the middle of it. Earlier, when you try to identify a particular action being quasi-judicial, some of the indicators that you might use is whether there are two contending parties. First thing, they're in, and whether there is a contest, which means a litigation, lis. See, lis pendens means litigation pending. So lis, lis means litigation. So whether there is a lis, and then whether the authority adjudicates upon the rights of the parties. Whether the authority adjudicates whether this party has this such and such rights, and whether this party has such and such rights based on the facts of the case. So when an authority tries to find out the rights of the persons and liabilities of the persons based on the facts, then we could say that the authority performs a quasi-judicial function. So in the similar manner, we were saying that when there are two parties and these parties are contending with each other, there is a litigation pending, and then the authority comes forward and decides the rights of both parties, then we could say that there is quasi-judicial function. So this was the earlier manner of identifying a quasi-judicial function. Later, what happened? However, when there is no litigation or contending parties, even when there is no litigation or contending parties, the function may be characterized as a quasi-judicial function, and the authority might be required to act judicially. Why? This was the next step. The earlier stage, we could identify the two contending parties. The earlier stage, we could identify the presence of a contest. All these things were there. But later, this process shifted. The focus not shifted from the proceedings of this function and the presence of these proceedings to the nature of the function. See, this is the perspective shift that has occurred in the later stage. This occurred with the case of Ridge versus Baldwin. See, I'm sorry that this is an online lecture and I don't have the luxury of a board to write down the name. Please listen to me very carefully and write down the case. RIDGE, Ridge versus BALDVIN. BALDVIN. Citation 1964 AC 40. Okay, Ridge versus Baldwin. In Ridge versus Baldwin, this perspective shifted to the duty to act judicially, rises from the nature of the function performed by the authority. See, earlier, how did we identify? We try to look into the procedure. See, there are two contending parties, and what is happening? There is litigation pending, and the adjudicatory body comes forward and it decides who is having such rights and who is having such liabilities, and then this is an adjudicatory function. This was what we were trying, we were doing earlier time. In the next stage, in this stage after Ridge versus Baldwin, what we are focusing on is what is the nature of the function that is being performed by the authority. Okay, so even if there are no contending parties, even if there is no litigation pending, the nature of the function itself, if it constitutes a duty to act judicially, due to the very nature of the function that needs to be performed, there is a duty to act judicially is coupled along with it. Then it is a quasi-judicial function. This reasoning was upheld in Maneka Gandhi versus Union of India, AIR 1978, SC 597. Maneka Gandhi versus Union of India, AIR 1978, SC 597. See, later there was an error. Later, in another case, not in this reasoning, there was an error committed by the court in a different case. This was in the case of state of Himachal Pradesh versus Raja Mahendra Pal. State of Himachal Pradesh versus Raja Mahendra Pal, AR 1999, SC 1786. AR 1999, SC 1786. In this case, what happened was that there was a two-judge bench and they arrived at the decision. They held that the primary test of determining that an authority is quasi-judicial is whether the authority has an express duty to act judicially in arriving at a decision. See, it means that the authority should have an express duty, which means the statute that confers power on this authority has made it expressly that there has to be a judicial the authority has to act judicially in this decision. Expressly, as statutely, it has to be mentioned that that the authority has to act judicially. Earlier, what was our stage? Earlier, what were we saying? We were trying to identify the nature of the function that is being performed by the authority, and then we will add judicial, we will say that this function is judicial. Due to the very nature of the function, then the court will identify, yes, to the very nature of the function, this is a quasi-judicial function. But now what happened? The court said that not all functions could be said as quasi-judicial. Only those functions which has been expressly provided the statute to be quasi-judicial. Those functions in which the statute expressly says that there is a duty to act judicially. There is a duty to act judicially. Only if such a clause is expressly provided in the clause, only then it could be considered as a quasi-judicial function. To identify the difference. See, this was a different perspective, but this was wrong. This concept was wrong. This decision in state of Himachal Pradesh versus Raja Mahendra Pal was wrong, because it ignores the concept in Ridge versus Baldwin, the Maneka Gandhi versus Union of India. In all these cases, the reasoning was behind identification of the nature of the duty which has to be given the importance. Okay, now later this view was proved to be erroneous, as the previous view held that the nature of the function creates a duty to act judicially. Later, in Sukhlal Sen versus Collector Satna, in that case, 1969, Madhya Pradesh Law Journal MPLJ 516. In that case, the court held that the nature of the function, the nature of the function of a licensing authority, of a licensing authority in cancelling occupational and trading licenses, occupational and trading licenses has been considered in detail by the Madhya Pradesh High Court. The division bench held that the nature of the duty, the division bench held that the nature of the duty to determine whether the licensee has committed any breach of terms, and conditions of his license, and whether for that reason license should be cancelled, imposes upon the authority the duty to act judicially, and to comply with the principles of natural justice, Okay. So, in next para, in Kothari filaments, Kothari space filaments, FILAMENTS, filaments versus Commissioner of Customs, CUSTOMS, Customs. The citation 2009 brackets, then 2 SCC 192. The Supreme Court held that the nature of action of authorities under Customs Act requires it to be considered as a quasi-judicial function. See, now we have shifted from the requirement in the particular case, in the state of Himachal Pradesh versus Raja Mahendrapal case, where it said that there has to be an express provision saying that express duty saying that the authority has to act judicially. That provision does not exist. That perspective was wrong. The duty to act judicially rises from the fact of whether the nature of the duty to be performed requires the authority to act judicially. This was the primary way of identifying a quasi-judicial function. Okay, now the authority exercising, next para, the authority exercising quasi-judicial power, the authority exercising quasi-judicial power is not bound by the guidelines issued by a higher authority. The authority exercising quasi-judicial power is not bound by the guidelines issued by a higher authority and has to be and has to be an independent view, and there has to be an independent view, has to take an independent view, has to be LA, has to take an independent view. See, this means that, see, administrative functions, you will have superior authorities who will give you guidelines on the basis of which the inferior authority is bound to take an action. But now, in this case where he is performing an administrative quasi-judicial function, he is not required, is not bound by the guidelines by higher authority, and he has to take an independent view while exercising quasi-judicial power. Now, the power of review of the courts. In this case, when of quasi-judicial functions, the authority which has taken the decision shall not have the power of review unless what? Unless the statute expressly gives him the same. See, right? The review of its own decisions, the review of its own means that of the quasi-judicial authority. The review of its own decisions is not permissible unless the relevant statute is not permissible. I'm sorry. The review of its own decisions is not permissible to a quasi-judicial authority. The review of its own decisions is not permissible to a quasi-judicial authority unless the relevant statute or statutory rules permits the same. See, in a departmental proceeding, it is a quasi-judicial function, and the quasi-judicial procedure, and the inquiry officer who performs it is performing a quasi-judicial function. The Supreme Court in Indian National Congress I versus Institute of Social Welfare, International Congress I versus Institute of Social Welfare, laid down the following principles to be characteristics of a quasi-judicial function. There are following principles to be characteristics of quasi-judicial function, and one of the characteristics are provided in that case. Now, the first thing, the court said that, so the court was trying to give certain characteristics which are common to quasi-judicial functions, where a statutory authority is empowered under a statute to do an act. Whether a statutory authority is empowered to do a statute and empowered to do something under a statute. Now, B, which would prejudicially affect the subject, and 3, although there is no litigation or two contending parties, and contest is between the authority and the subject. So even if there is no litigation and there are no contending parties, and the litigation is between the authority and the subject, and the statutory authority is required to act judicially, and the statutory authority, by the nature of the act, the statutory authority is required to act judicially under the statute, the decision of the said authority is said to be quasi-judicial. The decision of said authority is said to be quasi-judicial. There are two important incidents to a quasi-judicial function, two strong indicators to a quasi-judicial function. One, the quasi-judicial functions shall have to observe, quasi-judicial authorities while performing quasi-judicial functions has to observe the principles of natural justice. Two, once a decision has been taken by a concerned authority, it cannot review its own decisions unless it has an express authority to do so. There has to be an express authority to do so, otherwise he cannot review his own decision. Now, under section 29A of the Representatives of the People Act 1951, a political party has to register itself with the Election Commission. Okay, അപ്പോൾ election commission before the election commission, the political party has to register. Now, the concerned party has to apply to the commission for the purpose. After giving a reasonable opportunity for being heard, the representatives of the applicant's party, the commission decides whether the party has could be registered or not. The commission decides. Now, this action of the commission is quasi-judicial. Okay. Now, the Supreme Court has ruled that the Election Commission discharges a quasi-judicial function and it has to act judicially. Now, the court has observed that in view of the requirement of law that the commission is to give the decision only after making an inquiry, wherein an opportunity of hearing is to be given to the representatives of the political party, we are of the view that the Election Commission under 29A is required to act judicially, and in the view of the matter, the act of the commission is quasi-judicial. See, the 29A, when you see to it, the commission is required to listen to the representatives of the applicant party. An opportunity of hearing has to be given to the representatives of the applicant party. Opportunity of hearing, a principle of one among the Odi Altem Partem is one among the principles of natural justice, isn't it? So when you identify that the statute by itself requires the performance of one among the principles of natural justice, it is a very strong indicator that the particular function that has been performed by the authority is quasi-judicial in nature. Okay, so there is another case in National Securities Depository Limited versus SEBI. In this case, see, this same question of whether this function performed by, there was a circular, okay, there was an administrative circular issued by the SEBI under section 11 clause 1 of the SEBI Act of 1992, and whether against this circular could a matter of appeal, could it be preferred as a matter for appeal, an appeal be preferred from this particular against this administrative order under section 15T of the Act. Section 15T allowed any person who was aggrieved by any order of the board after the Securities Laws Amendment Act of 1999 could prefer an appeal before the tribunal. So the question was whether the administrative circular was appealable under section 15T of the Act. See, administrative circular has to be considered as a quasi-judicial performance of a quasi-judicial function or a quasi-judicial order. Then against that quasi-judicial order, whether an appeal could be preferred. This is why the order has to be classified as a quasi-judicial order in order to allow an appeal under section 15T. Okay, so they were trying to identify whether the issuing of administrative circular is a quasi-judicial function. This was the primary requirement. Now, the Supreme Court, after examining the subject, after examining the composition of the tribunal and the fact that the decisions of the tribunal were subject to the judicial review, upheld the decisions and held that to rule that an appeal to the tribunal could only be preferred against quasi-judicial orders of the board and not from its legislative or administrative orders. While adjudication in this case, during the adjudication of this case, the court has upheld that if it is a quasi-judicial function, then there can be a judicial review. There can be an appeal. But there cannot be an appeal from the legislative or administrative orders. So the question was whether from all sorts of orders of the board of the SEBI could there be an appeal. The court held that there can be appeal only from quasi-judicial orders and not from legislative or administrative orders. So this is the position that we have reached to, where we would say that the focus should be laid on the nature of the duty performed by the administrative authority, whether by its nature it requires the application of the it requires the authority to act judicially or not. It's not the procedure or it's not the manner in which that litigation is being placed should be given the focus. The focus should be on whether by nature it requires the authority to it casts a duty upon the authority to act judicially. Okay, so go through the cases of Ridge versus Bladwin, Maneka Gandhi versus Union of India, and the other case Sukhlal Singh versus Collector Satnam, Kothari Filaments versus Commissioner of Customs, and the last case of International Congress I versus Institute of Social Welfare, where all these are the cases which are required to be written in the topic when there is a question for quasi-judicial functions. Go through it and ask me any questions if you have any doubt. Okay, so I wish all of you have a good experience during your internship, and all the best.